Quick disclaimer, this is an AI voice, which is not going to be perfect. There is a transcript in the description as well as subtitles for you to read along with. Criminal courts are the method used to deal with criminal offences, with lay people making the decisions in these court cases. The criminal process starts in the magistrate's court, which hears 97% of all criminal cases. The magistrate's court has the jurisdiction to hear all summary offences, some tribal either way offences, and the first hearing of indictable offences. A magistrate's court has the power to sentence an offender to a maximum of 12 months imprisonment, give unlimited fines, and give a conditional discharge. The other main court that hears criminal cases is the Crown Court, which has the jurisdiction to hear some tribal either way offences and indictable offences. The Crown Court has unlimited sentencing powers and the power to hear appeals from the Magistrates' Court. There are three classifications of offences: summary, tribal either way, and indictable. Summary offences are the least serious offence and are heard in the Magistrates' Court. Examples of summary offences include driving without insurance, common assault, and criminal damage under £5,000. Tribal either way offences are middle-range crimes and can be heard in the Magistrates' Court or the Crown Court. The case will be heard in the Magistrates' Court if the defendant pleads guilty and the court has the power to sentence the defendant. If the defendant pleads not guilty or the magistrate's court does not have the power to sentence the defendant, the case will be sent to the Crown Court. Examples of tribal either way offences include theft, assault causing ABH, and obtaining property by deception. Indictable offences are the most serious crimes and are heard in the Crown Court, although the first hearing is heard in the Magistrate's Court. Examples of indictable offences include murder, manslaughter, rape, and robbery. Before the trial, there is an initial hearing where the defendant must plead guilty or not guilty. If the case is a tribal either way offence and the defendant pleads guilty, the case will stay in the magistrate's court as long as they have the power to sentence the defendant. If the magistrate's court does not have the power to sentence the defendant for their crime or they plead not guilty, then the case will be sent to the Crown Court. After the initial hearing, there is a bail hearing. This is where the court decides whether the defendant should be put on bail or remain in custody until the trial. After the bail hearing, there is an arraignment where the defendant is formally charged with their crime and they will receive information about the charges and their rights. After this, there will be motions, which are applications that cover various aspects of the case. These motions will include the exclusion of certain evidence, change of venue, or the dismissal of the charges. The appeal route for criminal cases starts in the Magistrates' Court and will move on to the Crown Court. After this, the case can be appealed to the King's Bench Division of the High Court, which can be from either the Crown Court or the Magistrates' Court. The case can then move on to the Court of Appeal and then the Supreme Court. A case can be appealed from the Magistrates' Courts to the Crown Court if the sentence was too harsh or it is believed that the defendant should not have been convicted. A case can be appealed from the Magistrates' Court to the King's Bench Division of the High Court if there is a mistake in the law or the law is applied incorrectly by the magistrates. A case can be appealed from the Crown Court to the King's Bench Division of the High Court if the law is applied incorrectly or there is evidence of a corrupt jury. A case can be appealed from the Crown Court to the Court of Appeal if the evidence was so weak that the defendant should not have been convicted based on it. There can also be an appeal if the law is wrong or if the sentence was too harsh. A case can be appealed from the Court of Appeal to the Supreme Court if the case involves a point of law that is of general public importance. Section 142 of the Criminal Justice Act sets out the aims of sentencing offenders. These aims are restitution, denunciation, individual deterrence, general deterrence, rehabilitation, public protection, and reparation. Restitution is where the offender is punished for their actions. Denunciation is where society expresses their disapproval for and condemns criminal activity. Individual deterrence tries to ensure the offender does not reoffend. General deterrence tries to prevent any potential offenders from committing crimes. Rehabilitation tries to reform the offender and get them back into society. Public protection is the aim of making the public feel safer by putting the offender in a place where they cannot commit a crime. Reparation tries to repair the damage done by the offender's crime, either by compensating the victim or by having the offender to community service. There are two types of factors that affect the sentence given to an offender, which are aggravating factors and mitigating factors. An aggravating factor increases the sentence that is given. These factors include any previous convictions, offences committed while on bail, any racial or religious hostility being used, any hostility towards disability or sexual orientation, or the lack of remorse. Mitigating factors decreases the sentence that is given. These factors include previous good character, youth or old age, domestic problems or ill health, remorse shown after the offense, a guilty plea, or helping the police with the investigation. There are two types of sentences that can be given to adults. These are custodial sentences and non-custodial sentences. A custodial sentence is where the offender is imprisoned for a specific period of time. This includes a mandatory life sentence, which is imposed if the offender has committed a crime where they have to be punished with a life sentence. With this punishment, the judge states the minimum number of years that they have to serve before they are eligible to be released. Custodial sentences also include a discretionary life sentence where the maximum sentence is life imprisonment, but the judge does not need to impose it. Custodial sentences also include a fixed term sentence where the offender has to serve a fixed number of years for their crime but is automatically released after serving half of their sentence. A non-custodial sentence or community order punishes the offender without imprisonment. This includes an unpaid work requirement where the offender has to work between 40 and 300 hours on a suitable project. Non-custodial sentences also include a prohibited activity requirement where the defendant cannot do certain activities to prevent them from committing another crime. Non-custodial sentences also include a curfew requirement where the offender has to remain at a fixed address between 2 and 16 hours a day. Non-custodial sentences also include an exclusion requirement where the offender cannot go to certain places in order to keep them away from areas where they are likely to commit crime. Non-custodial sentences also include a residence requirement where the defendant has to live in a certain place for a certain period of time. Non-custodial sentences also include a drug or alcohol rehabilitation requirement where the offender receives treatment to reduce their dependency on drugs or alcohol and must give samples for testing. Non-custodial sentences also include fines, which is an amount that the offender can afford but is not paid to the victim. Non-custodial sentences also include discharges where there is no punishment. A conditional discharge means the offender is not punished for their crimes as long as no further offense is committed for up to 3 years. An absolute discharge means the offender is not punished and there is no formal conviction recorded against them. Lay people are the people that are used to make legal decisions. There are two types of lay people, the magistrates and juries. A magistrate sits in the magistrates' court in a panel with two other magistrates. To be a magistrate, a candidate must be between the ages of 18 and 70 and are expected to live or work in or near the local justice area, which is the area their court is located. As well as this, the candidate must be prepared to commit to working 26 half days for 1 year or 13 full days for 5 years. Magistrates do not require any qualifications, but they do require certain character requirements. These requirements include a good character, good understanding and communication skills, social awareness, a maturity and sound temperament, sound judgment, commitment and reliability. There are certain restrictions that prevent a candidate from becoming a magistrate. These restrictions include having serious criminal convictions, having been bankrupt in the past, being a member of the forces, those whose work is incompatible, such as being a police officer or a traffic warden, those who have impaired hearing, those who are not physically or mentally strong, and those who have a relative working in the criminal justice system. When being appointed, the candidate must go through a two-stage interview process. In the first interview, the interviewers find out the candidate's personal attributes and explore their attitude for criminal justice. In the second interview, the interviews test the candidate's potential for judicial aptitude. The local advisory committee then interviews the candidate and submits the candidate names to the Lord Chancellor. The Lord Chancellor then appoints magistrates based on the recommendations from the local advisory committee. The role of a magistrate is to deal with summary offences and tribal either way offences where they will decide the verdict and the sentence. Magistrates also have to deal with the preliminary hearings for all criminal cases and deal with the first hearing for indictable offences. A juror sits in the Crown Court with 12 other jurors. To be a juror, the candidate must be between the ages of 18 and 75 and must be on the electoral roll. As well as this, the candidate must originally be a resident of the UK or the Isle of Man or be a resident for at least 5 years since their 13th birthday. A candidate may be disqualified from doing jury duty. A candidate may be permanently disqualified if they were sentenced to life imprisonment, they were detained for His Majesty's pleasure, they served a term of imprisonment for public protection, they had an extended sentence, or they served a term of imprisonment for 5 years or more. A candidate may be disqualified for 10 years if they served a term of imprisonment of under 5 years, had a suspended sentence, were given a community order. Any candidate who is on bail or has a mental illness are disqualified. A judge can discharge a juror if they lack the capacity to cope with the trial and fulfill the roles of a juror. This may be because they do not understand English or they have a disability that prevents them from completing their duties, such as blindness or deafness. When selecting a jury for a hearing, the list of potential jurors is divided into groups of 15 and allocated to a court. The court clerk will select 12 of these 15 potential jurors. When the jurors arrive at the hearing, they are shown a video that explains the court layout and procedure and tells the jurors how to behave. The role of the jury is to decide whether the defendant is guilty. To do this, the jury will retire to a private room and make their decision on the guilt or innocence of the defendant. An advantage of using juries in criminal cases is that they do not need to give a reason for their verdict, so they can decide the case according to their idea of fairness. As well as this, the jury helps make the legal system more open and allows the public to have more confidence in the criminal justice system. However, a disadvantage of using juries in criminal cases is that there have been instances where the juries have refused to convict when the outcome is clear. As well as this, there may be pressure from the media and a lack of understanding which will affect the verdict that the jury comes to. Thank you for watching this video on criminal courts and lay people. I'll see you in the next lesson.